Welcome back to Litigation Help. My name is Hui-Litwin, and in this video, we're going to talk about whether you can ask the court to punish your spouse for being unfaithful. So joining me here today to answer this question is Ontario family lawyer, Helena Birt. So Helena, can you go to court and hold your ex accountable for being unfaithful?
Well, if the question is, can you punish your spouse for being unfaithful? The short answer is no, but you can dump him or her an awful lot more quickly. So there's the shortest answer that I could possibly give you, but I'm assuming you want more than that, right?
I do, yeah. I guess it's kind of like, does adultery matter in divorce proceedings or separation proceedings?
It matters in divorce proceedings, but not probably in separation proceedings. So there's a couple of different things we have to look at, right?
Okay, yeah.
Okay, so what we're talking about are family law issues.
Mm-hmm.
So the first thing we're going to look at is, say that your spouse has cheated on you and you're very upset, and that's it, you said this relationship is over. So the first question is will I be able to get more spousal support because he cheated on me? And the answer is no. In Canada, infidelity has no impact on how our spousal support scheme is structured. Things like child support, child custody, spousal support, and property division are all what are called no fault in Canada. So it really doesn't matter if your spouse has been carrying on an affair with somebody else or a one-night stand or whatever. It doesn't have any impact on any of those issues that we talked about. So what that means is if you've been cheated on, you are not entitled to any more spousal support. Or on the other hand, if you were the one that was the cheating spouse, you're not going to have to pay more spousal support just because of the fact that you committed adultery. So it's one of those things. It's called a no fault issue because you're not going to get punished by having had an affair when you're dealing with one of those issues.
Mm-hmm.
So when you're talking, so that's what happens with spousal support. When you're talking about parenting orders for deciding what's in a child's best interest,
Mm-hmm.
the Divorce Act specifically says that you can't consider past conduct of a parent when making a decision-making or parenting time order. The only exception to that rule is unless that past conduct is relevant to the party's ability to act as a parent to the child. For example, if there's been a history of violence, that is something the courts will look at, again, because their concern is for the best interest of the child when they're looking at parenting terms. But just the fact that a spouse may have committed adultery, if it did not cause harm or impact on the child, then it's highly unlikely that it'll have any impact on a parenting order as well. So no, you can't just say, well, I never want him to see our child again because he slept with my next door neighbor. It just doesn't work that way. The one thing where it does come into play is the very technical rules on what entitles you to get a divorce. So the one thing that divorce or that adultery does impact is the period of time that you have to wait before you can get a divorce judgment. So basically, under the Divorce Act, which applies right across Canada, because it's a federal piece of legislation, there are 3 grounds for divorce in Canada. There's cruelty, there's adultery, and there's separation. So the definition of cruelty is when one spouse treats the other, and I'm reading right out of the Act right now, when one spouse treats the other with physical or mental cruelty of such kind that the spouses are no longer able to live together. Adultery is when one spouse has had sex with a person who is not their spouse. Only the innocent party can claim a divorce on the grounds of adultery or cruelty. So again, if I'm the one that goes out and has an affair, my husband I could not divorce my husband because I went out and had an affair. It doesn't work that way. Mm-hmm. The other really interesting rabbit hole you can disappear down is, what does sex mean? If you have a spouse that has a foot fetish and you've got a video of your spouse licking somebody else's boots, does that count as adultery? Or like, really, how do you define sex? So there's all kinds of really, really fun, interesting case law about what constitutes what adultery actually is. But anyway, that's taking us way out of field. Okay, those 2 are the fault grounds for divorce, either cruelty or adultery. If either of those grounds are in play, you can apply for divorce immediately as the innocent party if your spouse has committed either of those things. The kicker is the court's just not going to take your word for it. You're going to have to produce evidence. Mm-hmm. Now, in the States, there's a lot more baggage that attaches to the whole issue of adultery. And there are a lot of states where it's actually a criminal offense to commit adultery.
Wow.
And it has a real impact on what you might expect to get in the way of damages when you're claiming spousal support or parenting rights or anything else. So that's why in the States, there's a lot more huge industry on private investigators that are out trying to catch people sleeping with people they're not supposed to.
Right.
Because in a lot of the states, it makes a lot of difference. In Canada, it really, really doesn't. So those are the fault grounds for divorce. In Canada, all those things do is it means that you can apply for divorce immediately once you know one of these things has happened. But you're going to have the evidence to prove it. If the other side disputes it or denies it and says it didn't happen, then you're going to have to go through a trial, and then it'll be the judge that decides on the balanced probabilities who's telling the truth and who's lying about whether in fact the fault ground actually occurred or not. The third ground for divorce in Canada is separation, and that's called the no fault ground. So it's defined as having the parties living separate and apart for a period of at least 1 year. And once parties have been living separate and apart for a year, either party can apply for a divorce. And it doesn't matter what the reason was for the separation in the first place. Once the parties have been living separate and apart for a year, either party can apply for a divorce on the grounds of 1 year separation. In that case, the only thing that can be argued about is whether in fact the person that applies for the divorce is being honest about what they're claiming the date of separation is. And again, you'd be amazed at the amount of case law that's come out about saying, well, when exactly is the date of separation? So if you're going for a divorce, as long as you've been living separate and apart for at least a year, either party is entitled to get a divorce. And as I said, it doesn't matter. It could have been adultery. It could have been physical or mental cruelty that caused the separation in the first place. But once you've been living separate and apart for a year, the law deems your relationship to be over, and it entitles either party to commence a divorce proceeding on the grounds of 1 year separation. So that's the only thing that happens. So that cycles back to where we started. In Canada, adultery doesn't mean you can punish the other side by getting more property out of a property division or getting more spousal support. But what it does mean is that you can dump the person a lot faster if you can prove the adultery actually occurred.